Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology and IP transactions and keep you up to date on the latest trends in growth and innovation, digital transformation, IP and data monetization, and operational improvement by drawing on the perspectives of practitioners who have executed technology and IP transactions around the world. You can subscribe to the show on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today, artificial intelligence provisions in technology contracting, keeping up with the evolving regulatory landscape. I'm your host, Julian Dibbell. I'm a partner in Mayor Brown's technology and IP transactions practice. I'm joined today by my colleagues, Oliver Yaros, Gabriela Kennedy, Ana Bruder, and Arsen Kourinian. Oliver is based in our London office. He advises clients on technology and outsourcing transactions with a particular focus on artificial intelligence, fintech, and digital transformation projects, as well as clients operating within a broad range of sectors on data protection matters and cybersecurity incidents, IP transactions, and related issues. Gabriela is based in our Hong Kong office. She leverages her media, IP, information technology, and telecommunications law experience to help clients with technology transactions and solve issues in litigation and data privacy matters. She's handled many cyber incidents and has advised many companies on the adoption of AI solutions. Ana, based in our Frankfurt office, provides strategic advice in data privacy, cybersecurity, and related matters, including related EU legislation and, of course, the EU AI Act. Arsen, finally, is based in our Los Angeles office. He practices data privacy and AI law, including addressing new and evolving legal issues involving data processing technologies such as remote sensing from outer space. Arsen, Ana, Gabriela, Oliver, welcome. Let's get into it. So I want to start by asking, what are some of the major AI regulations in your respective regions that are important for companies contracting for or to receive or provide AI services? Maybe start with you, Ana.
Yeah, thanks, Julie. I'm happy to start. So in the EU, of course, we have the EU AI Act, which was the first comprehensive AI law in the world. Now, it takes a risk-based approach, which means that it's not like the GDPR with obligations that apply similarly to anyone who is a controller processing personal data. No, with the UAI Act, it really depends on the AI model or the AI system, specifically what is the level of risk of that AI system, for example. And it depends on the role of the party, if it is, for example, providing an AI system for use to another company, or if it is just using it as a deployer. Those two key factors will determine the obligations that apply under the UAI Act. And so, why is this relevant for contracting? Because when you're contracting and there's AI involved, you first need to understand what is the regulatory framework, what are the roles of the parties, who carries which obligations, are there any left to allocate? And you need to do all this from a regulatory perspective in order to reflect that into your contract.
Oliver, UK perspective?
Sure. Well, the UK up till now has taken a bit of a different approach, and this has been maintained by the current Labour government in the UK. So in January of 2025, the latest government announced what their AI ambitions were and laid that out in their AI Opportunities Action Plan. And what it said in that action plan was that the UK wanted to adopt and continue to have a pro-innovation approach, which involved taking a light touch approach for the moment. So there is no comprehensive AI law in the UK right now. What there is a framework which the government wants authorities to follow when issuing guidance under existing laws that touch on the use of AI. So the framework aims at promoting innovation and encouraging investment in the UK and encouraging adoption of AI in the UK. It is principle based rather than imposing rigid rules, and the framework allows regulators to adopt their approach as the technology and as the issues evolve. So at the moment, there are 4 authorities in the UK that are responsible for regulating the use of AI in their own areas, and they make up the Digital Regulation Cooperation Forum. They are the Information Commissioner's Office, the ICO, which is in charge of data privacy, the FCA, which is the Financial Conduct Authority, that's in charge of financial services and regulated sectors, Ofcom, which is the broadcasting regulator, and that's also relevant for online publications and online safety. And then the Competition and Markets Authority, which is responsible for antitrust. And what they've all done is issue their own action plans and guidance, which is being used to advise businesses using AI under their different remits. So, for example, the ICO has issued a publication about its strategic approach with respect to the use of AI that uses personal data. For example, high-risk AI applications that involve emotional recognition technology and biometrics. So businesses would be wise to follow the guidance with respect to that. In future, it may well be that the government does bring forward an AI specific piece of regulation, and a private member's bill has actually been proposed to that effect in the Houses of Parliament, but that has not got government backing at this current time. So for the moment, the UK approach is quite different from the EU approach. It's a pro-innovation, light touch approach, and that may be something that we see being adopted more widespread over the coming year. We'll speak about that in a little bit more detail later.
Gabriela, so from your perspective in Hong Kong, what are you seeing? Similar types of approaches or different?
So thank you, Julian. I'm not going to talk just about Hong Kong. I will talk about Asia, and I'm going to try and give you a very high level overview and just highlight 3 different approaches that we see across the region. So at one end of the spectrum, you have a place with stricter but very narrow regulation, which relates only to GenAI, and that is China. And here you have obligations involving regulatory approvals, completing required registrations and filings, having to undergo annual assessments, and of course, not dissimilar to what Anna was talking about, having labeling requirements, for your AI tools. In other countries, you will see an approach that is not dissimilar to the one that Oliver has mentioned, where countries have not opted for framework legislation for comprehensive AI laws, but rather have taken a more pro-innovation approach. There is a race towards being the country with the most competitive AI environment, and there the regulation is left to regulators. The obvious regulators, like in the UK, are the privacy regulators, the financial regulators, and in some jurisdictions like Australia, the health regulators. And then right in the middle, you have 2 countries that have actually issued AI legislation, and those are South Korea and Japan. The South Korean legislation sounded like and smelled a little bit like the EU AI Act in that it has a risk-based approach. But it has no prohibitions, and the government has backtracked and has decided that they want to take a softer approach, not dissimilar to that in Japan that has issued a law. but it sounds more like guidelines. It's a baseline from where the government allows and doesn't sanction companies, but names and shames and tries to enforce principles that relate to ethical behavior, transparency, and accountability. So those would be the three approaches. You have two jurisdictions with legislation, one country that has quite narrow legislation, and others that go for a more pro-innovation, softer touch, leaving regulation to the well-known regulators like the privacy, financial, and maybe health sector regulators.
Okay, so we've seen quite a range of legislative approaches around the world. Arsen, where does the U.S. fit in to that spectrum? What are you seeing in U.S.-based legislation?
Yeah, well, I mean, the US has taken a unique approach in the absence of a unified single federal law. We're seeing state by state AI regulations pass. One of the areas in which they're addressing AI is by passing a comprehensive AI regulation, which is in Colorado. And similar to the EU AI Act, it has different obligations for developers and deployers of AI systems, particularly for high risk areas where it involves very important decisions such as employment, healthcare, financial, and other categories. The other states, though, they're addressing AI by passing laws that are very specific to unique types of risks. For example, there are a number of states that have AI laws related to employment issues, such as avoiding discrimination, conducting bias audits, and being transparent when AI is used to make employment and hiring decisions. There are certain states with chatbot laws, which require being transparent with individuals that they're interacting with AI instead of a human being. And then we also have, in particular in California, very specific laws that apply to developers and frontier models on how they need to describe the type of training data that they use, being transparent with AI generated content and labeling, and certain reporting for frontier AI models. Now, how is this relevant for contracts? Well, whenever we're negotiating a contract, we try to evaluate which of these risk domains and laws may be triggered. For example, if it's a contract involving a developer or a user of an AI system in the employment context, we would want to think about stronger audit and testing provisions for algorithmic discrimination. And if the issue is more of a comprehensive AI law that gets triggered during a contract negotiation, we may want to include, for example, certain provisions requiring the developer of the AI system to furnish information about the AI system to the deployer so that the deployer can discharge their obligations. So the US landscape is quite complicated. There are well over 100 types of AI laws, and that further gets complicated by the intersection with existing laws of general applicability, which do not necessarily specifically apply to AI, but are broadly enforced to regulators by addressing AI risks that they are based on violation of these general laws.
Okay, well, thank you. That's a great overview of from around the world of the various uh, very complex and variable laws that companies are facing around the world. And Arsen, you touched a bit on what the contracting challenges are, particularly in the U.S. But I wonder if we could just sort of uh, talk about generally what the best practices are for negotiating AI contracts in the face of this kind of uh, multifaceted regulatory landscape. What are some common threads, common issues, and really general best practices that you all are seeing?
So, Julian, maybe I can start just with a regulatory note before we jump into the real like best practices.
Sure.
Under the UAI Act, as I mentioned, the basis question is what is the level of the risk of this AI system and what are the roles of the parties. Sometimes it's very clear cut. This will be a high risk AI system. This is the provider. This is the deployer. Fine. But you still need to know that so that you can put language in the contract. Sometimes it will be a general compliance with the law language, but very often this would not be enough. And I just wanted to mention that there are some scenarios where you need additional clauses in there. For example, white labeling of an AI system that is high risk, you will need to have some clauses in there because the party that is doing the white labeling becomes a new provider and carries all of the regulatory obligations. So this party needs to cooperate with the initial provider so that they have what they need to be compliant with the law, basically. Another scenario is very classic, really, licensing of a model in order to integrate it into a high-risk AI system. In this scenario, there are actually mandatory clauses on the same line of cooperation. So, you do need to understand first the facts and then what the regulatory implications are. And even outside of these scenarios, take a basic outsourcing scenario where the vendor is likely to use AI. More and more customers just want to know that they're using AI. So there may be some language in there, notify me when you're using AI. I want to know what the AI is, what it's for, liability provisions. Eventually, we don't want a cap to apply to anything related to AI risks, that type of thing. But that was just a tiny bit on the regulatory front. I'll turn over to you, Oliver, to talk about the best practices and move on.
Sure, Anna. I think, Julian, when you're thinking about using AI and what needs to go in the contract, I think it's always important to think, first of all, well, what are my AI use cases that I'm thinking of using, and how should those be addressed in the contract? So clearly, AI tools which have a higher risk profile, and Anna mentioned that risk rating is a central part of the EU AI Act and also other pieces of legislation. So use cases that have a higher risk profile should definitely incorporate more robust contractual terms that identify what role each party is going to perform and address that in a commercially reasonable way in terms of balancing who is going to be responsible for what, whether that's from a regulatory perspective or otherwise. Importantly, and as Anna mentioned, there are pieces of legislation that prohibit certain types of practices using AI. So the parties should consider whether including a contractual provision that says that neither party will engage in these prohibited practices is needed. I think that would be a sensible thing to include. But of course, when thinking about what the contract should look like, the parties do need to think about how detailed do they need to be. I think customers can take a balanced approach with this. I think they need to be thinking carefully about what the AI regulatory requirements are that they might be subject to, but not necessarily try and address those word for word. I have seen some contracts which try to do that, and they're pretty horrible to use and to negotiate. So I don't think that that is needed. But certainly there are core components of AI regulation and best practice that should be reflected in a contract where those pieces of legislation or where those guidance or industry standards apply. So, for example, making sure that the parties have agreed who is going to be responsible for risk management in terms of the development or deployment of the AI system, that there is going to be human oversight when it is used, that it's going to be monitored on a regular or continuous basis, that any transparency obligations in terms of informing users about how it's being used or subjects are complied with, that there are sufficient instructions provided about how to use it and who's responsible for providing those, who is going to be responsible for ensuring the safety and security of the system when it is deployed. So there are a number of components that can be addressed in the contract and should be addressed up front. And another thing that you should, of course, consider is whether it is necessary to have a compliance with laws, compliance with AI regulations clause in there, if in fact the regulations in the jurisdiction will actually apply to the use case that is being considered by the parties. And I think Arsen's probably got some more comments on that.
Great, thanks, Oliver. Yeah, I do think that as a very baseline provision in a contract, it's important to at least have a provision that says both parties will comply with their respective obligations, including under AI laws. However, that alone may not be enough, and there's several reasons for that. One is there may not exist a law in a particular region or applicable to particular residents of states or countries that apply to the AI system use case for the contract that's being negotiated. And the problem there is that if you just have a compliance with law rep, there is no type of assurance that the deployer will discharge certain safety protocols, or the developer, depending on which side you're on, will carry out its recommended practices. So often, in addition to a compliance with law rep, it's also helpful to think about having some type of representation about applying certain industry standards or complying with a particular risk framework so that there's alignment on both sides that they are both going to take certain steps to ensure that the AI system is both developed and deployed in a safe and secure and trustworthy manner. Also, if you just had a compliance with law rep, it wouldn't per se address data restrictions on the developer using your data to train AI models. Now, there could certainly be certain data privacy provisions that prohibit this from happening, or confidentiality provisions in certain contracts. But it's a bit unique when AI is processing data, like for example in California, when personal data is being processed by an AI model, the law has a specific provision that says that it's still considered personal information, but that type of clarity may not exist in all other jurisdictions. And then another thing to think about is trying to future proof your contract. Now, usually with both data under data privacy contract terms and the same with AI, I personally try to avoid specifically mentioning a long list of laws. The reason for that is because there could be certain regions again where those laws don't exist and don't apply, and you wouldn't have protections if you made it very narrow. And then second, this area, the legal landscape, domestically in the U.S. and internationally, is evolving very quickly, and laws not only that exist, but also future laws that may pass may require you to go back and rework your contract. So I try to address legal requirements in a harmonized way and a principle based way so that it applies across all jurisdictions and all scenarios so that you don't have to go back and revisit your contract constantly as new laws are passed.
Thanks, Arsen. Well, I will add two very quick points. The one is party leverage. As with every deal, the leverage of both parties counts, right? So major model providers, for example, they have their own online terms. They're unlikely to accept ad hoc terms, but they might, depending on the size of the customer, right? So it does make sense to discuss with them whether they have template provisions for particular use cases, and depending on how big you are, kind of test the temperature to negotiate. And then the market reaction would be my second point. AI terms are no longer foreign concept to companies, right? Even small to medium-sized companies now have AI terms when they're outsourcing, for example, and everybody in the market kind of seems to understand the need to use those terms, which have very clearly evolved since 2022. In the beginning, everyone was very focused on data, right? The use of data. Now, there's a focus on other aspects as well, like risk mitigation measures and other aspects that my colleagues already mentioned. So, from this perspective, it does make sense to start off broad and scale back depending on the AI use case and how the negotiations go.
So I'm going to jump in with, two more points. Of course, when you're negotiating and you're drafting your contract, many companies prefer to have their own standard terms. And how does that apply, to AI? Of course, you can develop your own AI policy, and depending on what role you're playing, it can be an AI policy that you would incorporate by reference into your agreement. You can also choose to have an AI addendum, a schedule to the contract with your preferred terms, and they will vary whether you're a deployer or whether you're a developer of an AI system. So, and already we've seen that happening. The other point I wanted to make was more to do with large LLM, or large language models, and in particular downstream LLM. So it's not just a situation where your AI provider is the one that has developed the LLM, but it may be that they are not actually training the AI model, in which case, when you're doing your contract and you're imposing obligation, you actually have to do some due diligence and dig deep and see what are the terms and conditions that the downstream LLM is actually imposing upon you, and how that is going to work in your contract and the various warranties and undertakings that you're seeking from the company that is actually providing the AI system to you.
Well, thank you. Those are some great considerations for companies to keep in mind as they contract for AI services. I'd like to sort of look to the future now, if we could, just a bit, to get a sense from you all of where we are now in terms of the regulations globally, and where this is all taking us. I mean, are we seeing some pushback to the regulations that may force a kind of course change and force companies to rethink what they're doing? What are our predictions for 2026?
My prediction for the UK is that there will continue to be a bit of a watching brief from the UK government over the next year in terms of how AI regulation is shaking out in other parts of the world, and whether it makes sense for the UK to bring forward its own AI-specific piece of legislation, or continue to try and shape public discourse through guidance and other requirements through existing legislation. I think the private members' bill to try and bring in AI regulation through the back door in the UK is not going to succeed. I think the UK is going to continue to see how things work out in other places. So I don't think that AI regulation is on the horizon for next year in the UK, but I do expect that there will be some regulation in the near future, because I think that that is the inevitable path that we are going down. And I think it is inevitable that the way in which we contract to use AI tools will be shaped by that going forwards. That's my prediction for the UK.
I'm going to jump in with Asia and say that probably, with a notable exception of China, most of the countries in Asia will continue with a soft touch approach to regulation, including those that actually have issued regulation and legislation already, and that they will be very much influenced by the OECD AI guidelines and focus on fostering trustworthiness, safe AI, promoting transparency, encouraging accountability. We've seen regulators actually urging boards to take responsibility and set up AI governance. And to this end, just yesterday, the Australian government announced plans to set up an AI Safety Institute.
Interesting. So in the EU, to your question, Julian, pressure from big tech, yes, absolutely. We're seeing this in the past few months, and European institutions did show, give signs of wanting to accommodate. And so what we have right now is this digital omnibus package that was proposed by the European Commission just last week. There's one for cyber and privacy and one for AI. But my personal opinion is that the changes that they're proposing there are small. They're not huge. They're not going to make a huge impact on companies that are subject to these frameworks. And still, no one's happy. Like it's, in my view, small changes, but still, the privacy activists already came criticizing, saying this is going to be the end of GDPR and laws that are so important to our values and all that. So I don't know, to be very honest, I personally do not think that this will be subject to substantive change this year, next year, or the year after. Maybe there will be slight changes that will be helpful. We'll see. And then one more thing to mention is on the informal side of things. I do think the commission is willing to help companies by saying, look, these laws now apply and you have to become compliant, but I won't start enforcing just yet, which is exactly what they did for the motor providers, the provisions that started applying last summer. So maybe there will be some of that, but I don't expect a formal grace period because they've already said no to that a number of times. And just one note, I don't know if this is very helpful actually to our clients, to companies doing business in the whole world. One client was just telling us this yesterday. They had a budget for compliance and contracting, taking into account all these regulatory frameworks. And with all these discussions on putting a pause, they don't have a budget anymore. But there's no certainty that these things will not apply next year, right? So you're really between a rock and a hard place. I wonder if it wouldn't be best to just keep on track rather than this huge debate that just creates legal insecurity. Over to you, Arsen.
Yeah, in the US on the federal level, I certainly don't anticipate a comprehensive AI law passing anytime soon, though the Trump administration is very focused on preempting state AI laws. The current federal government is taking a pro innovation approach, and they're looking for ways to avoid hindering progress in AI development in the global AI arms race that's going on. On a state level, I also don't anticipate a lot of states following the Colorado AI Act comprehensive law. There initially was some appetite by states to also pass such a robust AI law. For example, the Virginia legislature passed it, but it got vetoed by the governor. And Connecticut was also looking into passing a comprehensive AI law, but that didn't go through. So instead, I do see in 2026 the current trend continuing, which is states passing very narrow AI laws that address very specific types of risks, such as employment or transparency, or in the context of healthcare or protecting children. But I'm not anticipating a lot of dominoes to fall on a state by state level for comprehensive AI laws. An open question, however, does remain to the extent to which the Trump's administration's efforts to preempt state laws will succeed in curbing state activity.
All right, thanks, Arsen. Thank you, Ana, Gabriela, Oliver. Always great to have you on the podcast. And thank you, listeners. If you have any questions about today's episode or an idea for an episode you'd like to hear about anything related to technology and IP transactions and the law, please email us at techtransactions@mayorbrown.com. Thanks again for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.